Hey everybody, welcome to our very own Law Shanty. So we're going to start the Shanty today with a vocabulary phrase. Not a vocabulary word, a vocabulary phrase. And the vocabulary phrase for today is stare decisis. Now what, might you ask, is stare decisis? Well, the translation from Latin is to stand by things decided. That's what stare decisis means. It's basically the doctrine whereby courts follow precedent, right? You all know what precedent means. You do something one way, and then when a similar set of circumstances arises, you do it the same way. That's precedent. We set precedent, and we see the word precedent often in the union context. We bring somebody back, and we'll say this doesn't set a precedent, or we enter into a last chance agreement and we say this doesn't set a precedent. For the courts, stare decisis and precedent is an important concept. Now, look, there's two kinds of stare decisis. There's horizontal stare decisis and there's vertical stare decisis. Vertical stare decisis is easy, and it is pretty much a rule. That is, a lower court has to follow the decisions of the courts above it. So when the Supreme Court of the United States speaks, all the lower courts, it's the law of the land, and all the lower courts have to follow that. Horizontal stare decisis, on the other hand, is where a court follows its own precedent. So the Supreme Court follows its own precedent. That's a little more flexible. It is not absolute. And I think we would all agree that you don't want to necessarily be bound by something if that decision was wrong. You don't want to be bound by a decision forever just because a court made it, if that decision was wrong. Now, I will tell you that it is still pretty rare, despite recent events, for the Supreme Court to overturn one of its precedents, but it does happen. And I'm going to give you an example. It's not the one you think. In 1896, the Supreme Court of the United States decided a case called Plessy versus Ferguson. Some of you may know what Plessy versus Ferguson is, but it was in the aftermath of the ratification of the 14th Amendment. It involved the doctrine of separate but equal, where the Supreme Court of the United States said all the 14th Amendment requires is that the races have equal facilities. They don't have to be the same facilities. So we can have a rail car that is only for African Americans, and we can have a rail car that is for white people. And that's basically what Plessy versus Ferguson held. I think we would all agree that that's just wrong. It's wrong. It was wrong then, it's wrong now. That's not what the 14th Amendment held. But we didn't get that overturned, because of stare decisis and precedent largely, until Brown versus Board of Education came along in 1954. And Brown, the Supreme Court, different case, that involved education, not rail cars, but the Supreme Court specifically overturned Plessy versus Ferguson. And they said, when prior decisions are unworkable or are badly reasoned, then the Supreme Court must not follow its precedent. And this is particularly true in constitutional cases. So why am I telling you all of this? I find it interesting. I'm also telling you all of this because I don't want to talk about the courts today. I want to talk about the National Labor Relations Board. Now, those of you that work in traditional labor law, that have unions, and even some of you that don't, fully understand that the National Labor Relations Board doesn't ever feel bound to follow precedent, that the board changes its mind all the time. And I'm going to use a specific example for you right now. In 2019, the Trump board, in a case involving Wal-Mart, had previously held that the quote-unquote special circumstances test applied only when an employer completely prohibits union insignia, and that lesser size and appearance restrictions on union insignia could be deemed lawful based on less compelling employer interests. In other words, you didn't necessarily need to prove special circumstances, that your facially neutral policy was presumptively lawful as opposed to presumptively unlawful. And that's what we're going to talk about today. We're going to talk about dress codes, union t-shirts, and the National Labor Relations Board. And we're going to do it in the context of a case that just came out on August 29th called Tesla Inc. All right, here's what happened in Tesla. For those of you that follow the news, you know that Elon Musk doesn't exactly have a stellar record when it comes to union relations. He's already been found to have violated the National Labor Relations Board with one of his tweets, where he tweeted something like, if you support the union, I'm going to take away your stock options, or something like that. I don't remember exactly what it was, but the board found that tweet to be an unfair labor practice and made him take it down. Now, what we've got is a situation that arose in 2017 where a production associate at Tesla wore a black cotton t-shirt containing small logos with a union campaign slogan on it. On the front, it said, quote, "Driving a fair future at Tesla." And on the back, there was a big UAW, you know that UAW kind of wheel logo they have? It had the big UAW logo on the back. Now, this particular production associate was subject to the Tesla dress code. And the Tesla dress code said you had to wear, quote unquote, team wear. Team wear in this context was a black t-shirt with the Tesla logo on it and black pants. Now, Tesla occasionally would allow people to substitute an alternative black clothing for the black Tesla t-shirt. But you had to have supervisor approval. And Tesla also said, the policy also stated that alternate clothing must be mutilation-free, appropriate for work. I assume mutilation-free means you're not changing it or tearing it, doesn't have holes in it, something like that. It has to be appropriate for work and pose no safety risk. Those things make complete sense. To have a dress code that says you've got to have something that's appropriate for work and doesn't pose a safety risk. We don't want loose clothing or a necktie getting caught in a machine and pulling someplace off. Now, the employee in this case, because they weren't allowed to wear the union t-shirt during the union campaign, the union filed an unfair labor practice charge. And I'm going to read to you from the board, the press release, not the decision. The decision's 19 pages long. And it was a 3-2 decision. There was 2 dissenters. Big surprise. The dissenters were the Republican board members, and the majority opinion was the Democratic board members, Democratic appointee board members, including Chairman McFerrin, members Wilcox, and member Prouty. So, in this case, which is Tesla Inc. 370 NLRB number 88, 2021, the board overruled a Wal-Mart decision from 2019, and they said the following. The board reaffirmed that consistent with Republic Aviation Corp. Versus NLRB, which is a 1945 Supreme Court decision, when an employer interferes in any way with the employee's rights under Section 7 of the National Labor Relations Act to display union insignia, that interference is presumptively unlawful, and the employer has the burden to establish circumstances that make the rule necessary to maintain production or discipline. And then the board said, they found in this 19-page opinion, that Tesla failed to prove those special circumstances. So Tesla argued that they had special circumstances. They made a couple of arguments to do that. They argued that the team wear policy, the dress code policy, was intended to aid in the quote-unquote visual management of the General Assembly plant and to lower the risks of the employees' clothing, causing mutilations to the vehicles as they were produced. The board rejected the whole argument. They said, first of all, there's no evidence at all. This falls under the bad facts make bad law argument, right? They said there's no evidence at all that a black t-shirt with a union logo on it, as long as it's clean and not torn up and all that stuff, is any more likely to cause damage to a vehicle than a black t-shirt with a Tesla logo on it. Well, it makes sense. It's not a very good argument on Tesla's part. The other thing that Tesla argued is, look, we use these black t-shirts with the Tesla logo on it to know that people are in the right place. And the board found two problems with that. Number one, first of all, you deviate from the policy occasionally and let people wear other black T-shirts. And second of all, what's the difference between a black T-shirt with the Tesla logo on it and a black T-shirt with a union logo on it if you're really trying to figure out if people are in the right place because they're wearing a black T-shirt? A black T-shirt is a black T-shirt. It's not a red T-shirt. It's not a white T-shirt. It's not a yellow T-shirt. It's a black T-shirt. All right? There's some argument that maybe the employees can't wear the union red solidarity T-shirt. I don't know. So the dissent in this case said, whoa, wait a minute. You're distorting, quote, decades of precedent teaching that employee rights and legitimate employer interests must be balanced, end quote. The big question coming out of this decision is, all right, can we ban union wear ever? Because the dissent here is saying, look, effectively what you're doing here, majority, is you're saying you can never ban union wear ever. Because it'll be almost impossible to prove special circumstances the way you have outlined special circumstances. Now, the majority went to pains in its night. I mean, they really tried hard to explain that its decision does not abolish an employer's ability to maintain facially neutral dress code policies as long as there are special circumstances. So what kind of special circumstances are we talking about? I think the likely area where you're going to continue to see the special circumstances is in the area of retail and healthcare, where we've seen them all along. All right? In other words, if you are in a customer-facing role and you have a uniform dress code policy, you are probably going to continue to be able to prohibit deviations from the dress code policy as long as it's facially neutrally applied. So if I've got a dress code and I'm required to wear a golf shirt with my logo on it when I'm out on the retail floor, I'm not going to be able to substitute a golf shirt with a union logo on it. But if I'm behind the house, I'm going to have to be able to prove special circumstances in a much more robust way. All right? Now, there's two things that we know are going to come out of this. Number one, we're going to get tons of unfair labor practice charges now every time somebody walks in with a union T-shirt on or a union button on or something like that. And by the way, Tesla allowed the employees to wear union stickers, but they had to wear the T-shirt. And the second thing we're going to see is an appeal. I think it's highly likely that Tesla's going to appeal this. So we're going to have to see what the courts ultimately have to say about this. And that's when stare decisis will actually matter again, bringing us full round to the front. So if you've got any questions about your dress code policy and what it means after Tesla, give us a call. Great seeing y'all. We'll see you next time.